4 for Journalism 302 in the summer of 2017. In the 3 introductory lectures, you've seen how the courts work. We saw the case of Liebeck versus McDonald's. You've looked at philosophies that advocate for and against freedom of expression. And here in these and subsequent lectures, we're going to turn to substantive law. That is to say, the actual law that is used. It's interesting. The philosophies that you've seen, they can help explain or rationalize the reasons that courts rule the way they do. But when it comes to court cases, and very importantly for you on exams, you're going to have to refer to substantive law, the court cases, the precedents, and the rules that will help you resolve controversies. As you saw in the one lecture about the libel case, there are rules that have to be applied. You'll notice that in that example question, I didn't go into philosophies for freedom of expression because they're philosophies. They aren't actually the law. So it's good for you to understand philosophies. They're very helpful to us. They often are discussed in the opinions that lead to substantive law. But I warn you against saying something like marketplace of ideas, therefore the government can't restrict speech. The philosophy may be invoked by a judge in explaining his reasoning, but it's the actual rule that you're going to have to apply. Second thing to think about is that we're going to be talking about some bad stuff. Speech is a tool. It can be used to build things, but speech also can be a weapon. It can be used to damage and harm things. We're going to talk about some cases that involve conduct which, well, it's disgusting. I'm not going to make you actually look at the disgusting speech, but we will talk about the cases and I will describe some of the content that you will probably find to be distasteful. All right, so let's move on. We're getting into substantive law. We're moving away from philosophies, which are nice to have in the background, but here are the rules of law that you're going to be using on the exam and in your professional careers. So, the First Amendment. Here we're talking about protecting speech, and of course the First Amendment is the core. You'll know that the First Amendment starts with the 5 words, Congress shall make no law. And the Supreme Court for many years considered that to be a restriction on what the First Amendment protected. The Supreme Court held that the First Amendment protected speech against federal action, that is to say, action by the federal government, laws passed by Congress, actions by the executive branch, but that was the limitation. And states were not subject to First Amendment restrictions. If your state wanted to pass a law making it a crime to publish the name of the governor, the First Amendment didn't protect that. It was subject to states. Now, every state constitution has provisions to protect expression, but as we'll see from some court cases, those state constitutional protections were not always very effective. So here we are, the First Amendment applying to the federal government, but we know today that the First Amendment does apply to both state and local efforts to restrict speech. When did that happen? Well, it happened in 1925 in the case of Benjamin Getlow versus the state of New York. Mr. Getlow was convicted of violating the criminal anarchy statute in New York. For those of you who are not familiar with criminal anarchy, it is a crime to work to destroy established order. At the turn of the previous century, there were people who said that society wasn't working, that the wealth of the nation was concentrated in the hands of a very few people, and most folks didn't have a whole lot of money. Neither did they have effective political party because the people with wealth controlled the political system. So folks said, we need to change this. Some advocated communism, in which there would be collective ownership of the means of production. Some advocated socialism, in which private property rights would give way to the needs of the members of society. Some advocated anarchy, which said we should have no established system. And it was more than just a philosophical discussion, because people took steps to destroy the established order. There were assassinations, there were bombings, and of course society responded to this by passing a lot of laws making it a crime to advocate these things. So Mr. Gitlow and his friends circulated a pamphlet called the Left-Wing Manifesto, which was advocating communist socialism. So it was a 2-for-1. And the manifesto said, take the money out of the few, redistribute the wealth to the whole of society. And of course that scared the heck out of the people who were in charge of society and the political system. He was arrested, charged, convicted, and sent to prison. Then he appealed to the United States Supreme Court, and surprisingly the Supreme Court took the case. The Supreme Court did two things. The first you can see on your screen. The most important thing, the court held that the First Amendment was a fundamental right that applied to the individual states through the operation of the 14th Amendment. You'll recall from your history classes that the 13th, 14th, and 15th Amendment, the post-Civil War amendments, were created to ensure that everybody would enjoy the protections of the Constitution. Everyone would enjoy equal protection under the law. So now in 1925, the Supreme Court holds that if a state passes a law, or even a local community passes a law, that violates people's expressive rights, the First Amendment could be applied to hold that law to be unconstitutional. Oh, the second thing the Supreme Court did, which is not as important, well, at least to us, but very important to Mr. Gitlow, was they upheld his conviction. They said, Mr. Gitlow, you're in prison, you're staying in prison. But case important for all of us because it nationalized the First Amendment. Now, it's not just the First Amendment to protect speech. We also have protection under the Fifth Amendment. The Fifth Amendment, of course, you're familiar with it, not being compelled to testify. But the second part of the amendment, the Due Process Clause, says that they can't take away your life or your liberty or your property unless they follow due process of law. And this is significant to us. Our case from the textbook Southeastern Promotions versus Conrad, this is a case involving an off-Broadway musical play which subsequently went on Broadway. The play was called Hair. It was written and produced during the period of the Vietnam War, and it was an anti-war musical, hippie musical. It opposed the war. It said terrible things about President Richard Nixon. It had a number of songs that are still popular today. It probably was most famous because it involved the entire cast disrobing at the end of the first act and the audience being confronted with full frontal nudity. Now, this was produced off-Broadway at the time, but it was a popular musical. Some years later, somebody brought out a traveling production of Hair. It was going to play in an auditorium operated by a county official. Learning that Hair was the production, said, you can't show that terrible play in the county auditorium because it has hippies, references to drugs, it has full frontal nudity, and it says terrible things about now former President Richard Nixon. And he locked him out. The company that was running the traveling production sued. And in that case, the court held that the theater production being locked out of the theater without a court hearing, without being able to challenge that action, was denied due process of law. So if you are in the government and you want to prevent something from being expressed, something from being put on, you have to go through the process of getting a court to agree with you that the production or the expression should not take place. And the persons whose speech is being denied have to have the opportunity to speak to that and make their own arguments to the court so that the judge can consider both sides before rendering a judgment. And so in this case, in Southeastern Productions, there was no such hearing. The county official just took it upon himself to lock out the production, and that deprived Southeastern Promotions of due process of law. One thing to keep in mind is that due process does not mean fairness. Due process simply means that there is a procedure that has to be followed. For example, I used to be a journalism department chair back at Idaho State University. I also taught classes. If a student wanted to contest a grade in one of my classes, they of course would, that student would come to me, make an argument, and I would say, well, yes, I'm changing the grade or I'm not changing the grade. If I didn't change the grade, the student could appeal, and the student would appeal to the department chair, me. So I, the faculty member who said, no, I'm not changing your grade, would now be the department chair sitting in judgment of the faculty member saying, I'm not going to change your grade. And so if a student appealed to the department chair, not that this happened, I would be able to say, no, I am not going to change the decision by the faculty member, and the student would have gotten due process. Now, the student probably would have said that's not fair, but it is the procedure that was in place. Not to worry, even if a department chair doesn't agree in endorsing his decisions as faculty member, students still have the opportunity to go up the chain to appeal a grade to the Office of Student Rights and Responsibility, ultimately the provost and the president. But just understand that due process means that there is a procedure that has to be followed, and if you don't follow it, then your action is not constitutional. Here we are in video 5, and now let's take up the topic of overbreath. Now you can tell it's a reference to being too broad. And here's what overbreath is and how we apply it to speech in the First Amendment. There are problems, so the legislature creates a law to address the problem. The constitutional issue is that with overbreath, the law does more than simply address the problem. It is overly broad and prevents otherwise legal activity. So let's take up the example of drinking and driving. It's a problem. One way to solve drinking and driving would be to ban the sale, possession, and consumption of alcoholic beverages. Problem solved. But not really, because the law means that lawful drinking would now be illegal. And so the ban on alcohol would be overbroad in that it prohibited the bad conduct along with lawful conduct. And forgive the typo in the last bullet point. So overbreath is you passed a law for a good reason, but you've made the law so broad that it also makes illegal lawful things. And it happens a lot with respect to speech and expression. We don't like the use of one term, so we're going to make it illegal, but then that affects the legal use of the term. Here, we'll be talking about something called crush videos. I'm sure that none of you have seen crush videos, but they are made, marketed to satisfy consumers who want to watch attractive young women killing small animals by stepping on them. It's sort of a BDSM thing. The women often are dressed in latex or leather. Their identities are concealed by masks or hoods. There's a soundtrack, and they are slowly stepping on small animals to kill them. It's pretty distasteful. Well, Congress learned about this, and a member of Congress sponsored a bill that would make it illegal to sell such videos, which sounds like a good thing. It's solving a problem. And someone was arrested and convicted for selling these videos. and the person appealed. So the person was arrested, convicted, appealed at the Circuit Court of Appeals, won. So the United States appealed to the Supreme Court, which is why this is U.S. versus Stevens. And so here's the analysis. As I said just now, we create laws to deter or punish particular actions. But if the law makes illegal or punishes legal activities, it's overbroad. And even though you're going to stop the bad thing, the fact that you're also stopping legal things makes it unconstitutional. So in Stevens, the relevant portion of the law that says any visual or auditory depiction in which a living animal is intentionally maimed, wounded, or killed. Those are the important parts. Now, it's illegal if the killing or wounding takes place in a state or federal district where it's illegal to do this. You can see there in that slide. Well, in California, hunting is not quite as popular as in other states. In Idaho, hunting is a big deal. In Texas, hunting is a big deal. Oklahoma, hunting is a big deal. But in the District of Columbia, where the case was brought, all hunting is unlawful. Well, the problem is, if it's unlawful to hunt, that is to say, to shoot with a rifle or shoot with an arrow, to wound and kill an animal, then it means that all videos that show people shooting animals, killing animals, is illegal in the District of Columbia. And if you are familiar with popular culture, you know that there are magazines about hunting, there are web programs about hunting, there have been television shows about hunting. If those are shown in the District of Columbia, the people who market those or sell the magazines would be at risk for prosecution under the anti-crush video law. So, you've got a hunting video, you're hunting elk in Idaho, you sell it at a sporting goods store in the District of Columbia, selling that video would be a crime because it's illegal to hunt in the District of Columbia. Now, if it's illegal in the District of Columbia, then it would affect the production and sale of the video elsewhere. People would have to be sure that the video was never sent to the District of Columbia or brought to the District of Columbia for sale. They'd have to watch if a television show was seen in the District of Columbia, if a website showing hunting was shown in the District of Columbia. That's the big deal about that. So there's a good aspect to this, there's a bad aspect to this. So in United States versus Stevens, the Supreme Court said the fact that this would make a hunting video or a hunting magazine illegal means that it's overbroad. Now, the government said, oh no, we would never prosecute a hunting magazine or a hunting video or a hunting website. We would only prosecute the people selling these crush videos. But Chief Justice John Roberts said, yes, you're promising that you will be nice and won't misuse this, but a government promise doesn't make it constitutional. And the Chief Justice said, administrations change, there's a different way to approach crimes, there are different attitudes about hunting, so it's not enough that the government would promise only to apply this against the bad conduct. And so the Supreme Court held that the crush video law was unconstitutional because it was overbroad. Let's move on to sedition. Here is where the government punishes speech, and sedition is speaking out against the government. We have sedition as part of the legal tradition we brought from England with William Prynne, John Twynne, and John Peter Zenger. Of course, the colonial experience. William Prynne is a Puritan. He spoke out against certain entertainment activities. He was against dancing. He was against plays. And he wrote that any woman who acts in a play is a whore. And then it turned out that the Queen of England had acted in a Christmas pageant, a play. So he was criticizing the Queen of England, and this is decades ago. And for that, he was arrested, convicted, and sentenced to be locked up in the stocks. He had an ear cropped off for speaking against the government. John Twynne was a printer. He wasn't actually an author or a speaker. He was a printer, and he had the bad luck of printing a book that said that if a monarch, a king or a queen, does not serve his or her subjects, then the subjects are entitled to overthrow the king or queen and kill them. And of course, in England, which has a king or queen, this was just a radical idea, and the government was not happy. So they arrested Mr. Twynne, said, "Tell us who the author of this book is that you published." And Twynne said, "No, I can't. This is an anonymous author. I'm going to respect his anonymity. I'm not going to tell you." So since the British government couldn't find the author, they punished Mr. Twynne instead, and they cut off his head, they pulled his arms and legs off his body, they cut him open and hauled out his entrails and set them on fire. So speaking out against the government is a big deal. Then we had the case of John Peter Zenger. This is happening in colonial America. John Peter Zenger criticized Bill Cosby, not the Bill Cosby in the news today, but Governor William Cosby, who was the governor of the colony of New York. Zenger criticized him in a dispute where he wanted to take half the salary of his predecessor because he said he was entitled to it. That criticism of the governor led to a criminal trial. In the criminal trial, Andrew Hamilton, not Alexander Hamilton, not the guy from the Hollywood, the Broadway play, Andrew Hamilton spoke out about the right of Englishmen, because Americans were English at that time, to be able to speak freely and openly. And he encouraged the jury to find Mr. Zenger not guilty because he was simply engaging in a practice that Englishmen had long enjoyed, speaking out, speaking their minds. So we have seen that speaking against the government can get you mutilated or killed, or sometimes protected by a jury of peers. We've had sedition laws here in the United States in 1798. Remember, the First Amendment went into effect in 1791, so here it is 7 years later, and Congress passes a law making it a crime to criticize the President, the Congress, or the United States. This was in a period of great uncertainty and unrest. You'll recall from your history classes that we had won our freedom with the aid of France. France then underwent the French Revolution. The French monarchy was overthrown. The French aristocracy sent to the guillotine. England was engaged in a war with France. We were neutral and selling stuff to both sides. And each side was unhappy we were selling stuff to the other side, so the English started raiding our commerce, and the French started raiding our commerce as well. We settled with the English. We made a treaty with the English in which they would stop raiding American shipping in return for some benefits, and that really ticked off the government of France, and so they stepped up their commerce raids against American ships. The French Revolution, with fraternity, liberty, and equality, was seen as the communism of its time. There were concerns that the French Revolution might be exported to the United States because there were a lot of French people here. There was concern that the French might decide to invade the United States and make the United States part of the grander French Revolution and new French political movement. And of course, there were the Francophiles, the people who liked France, like Thomas Jefferson, and there were the Anglophiles, like John Adams. Adams and Jefferson were both running for president. We had made this treaty with England. The French had responded with commerce raids, so we sent a delegation to France. Before the French would discuss terms with the American delegation, they demanded a bribe. This was the famous XYZ affair that you read in your history books in public school. News of that bribe demand was leaked to the public. See, we have had leaks for as long as we've had the United States. It enraged the populace, and so in the presidential election, Adams won. Jefferson got the second highest vote, which meant that Adams would be president, Jefferson would be vice president. It was a different system back then. We didn't have running mates. We had the winner, top vote getter president, second vote getter as the vice president. Adams was concerned about the fact that the company was politically divided, and it was. There were newspapers that were pro-Federalist, pro-Adams. There were newspapers that were pro-Jefferson, pro-Republicans. And when I say Republicans, it's not the same Republican Party we have today. Republicans of Jefferson were more akin to the Democrats of today. Anyway, there were some really nasty things said about Adams and Jefferson. Jefferson was called the Antichrist. Adams was called the querulous, balding old man with delusions of kingship. These publications, the political divisions, the possibility that we might be attacked by France or that France would export its revolution to America, led Adams and the Federalist majority in Congress to pass the Sedition Act of 1798. It was an attempt to reduce political tensions. And the way they were going to do that is they said, we'll simply make it a crime to criticize the President, the Congress, or the United States. Therefore, speakers and publishers will not be able to stir up resentment. Which, yes, I guess you could say it would solve the problem. Of course, it meant that people on the other side could continue stirring up resentment. It had no effect on that. There were 13 prosecutions, 13 convictions. Among the persons convicted was Matthew Lyon, a sitting member of Congress who had criticized Adams in a letter to an editor in a newspaper. Also, the father of the New York State public education system, prosecuted, convicted, sent to prison. A fellow who was a Revolutionary War veteran and wandered the countryside selling his own political tracts door to door was prosecuted, convicted, and sent to prison for erecting a liberty pole. Liberty pole was the 18th century version of the political billboard. And in his political billboard he said, peace and retirement to the president, long live the Republicans. And for that he went to prison. And then we had Luther Baldwin. Luther was a fellow living in Philadelphia. And President Adams was going home for the summer. He went through town. And of course, the president going through town was a big deal. They had church choirs out there. They had people lining the streets. They were firing cannon salutes. And Mr. Baldwin and a friend of his were in a bar, and they were listening to all this thing going on. They were ringing church bells. And Mr. Baldwin's friend said, oh, look. Of course, they were drunk. oh, there goes the president, and they're firing at his ass. Ha ha ha. And Luther Baldwin, being drunk, of course, decided to one-up his friend and said, no, no, there goes the president, and they're firing cannonballs through his ass. Well, there was a Federalist guy in the bar, and he overheard the conversation. He was aghast that anybody could speak so disrespectfully of the president. He went and found a federal marshal. They arrested Mr. Baldwin and his friend. The next day they sobered up. They were taken before a federal judge, and despite their apologies, both Mr. Baldwin and his friend were fined an amount of money. They didn't have the money, so they went to prison to serve the debt that way. Stories about the prosecutions under the Sedition Act were very unpopular. People said, well, you know, I could be talking to my brother-in-law at a party and say something bad about the president or the Federalists. Am I going to go to prison too? So in the next election, Jefferson was voted in as president. The Republicans gained control of Congress. And the Sedition Act of 1798 was not renewed. And ultimately, Congress passed a bill to repay the persons convicted, to repay them the fines they had been assessed. So, 7 years after the First Amendment, Congress made a law restricting speech. So sedition is a big deal for governments. The Espionage Act of 1917 made it a crime to oppose the draft or the war effort. And the Espionage Act of 1917 is still relevant because it still is in effect, and certain parts of the Espionage Act make it a federal crime to possess secrets of the United States. So Chelsea Manning, who leaked secrets about the Iraq War and diplomatic cables, faced charges under the Espionage Act. Not convicted, but faced charges. John Snowden could face charges under the Espionage Act. Julian Assange of WikiLeaks, if he were ever brought here, could face charges under the Espionage Act. It has been used as a threat against journalists when they publish leaked secrets of the government. So that's something to be aware of. The Smith Act of 1940, a peacetime sedition law, making it a crime to advocate the forceful overthrow of government. There you have it. Advocating the forceful or violent overthrow of government is a crime. So if you publish or say, then you can go to prison. There's a but though. Teaching or advocating the violent overthrow of government is not illegal if it's taught or advocated as an abstract doctrine. So you're here taking courses in college. You're maybe in a political science class, and in the political science class they may talk about communism or socialism. And your professor may say, well, it's a much better system, and if we had that, we wouldn't have the 1%, and we wouldn't have the inequalities. There'd be a land of paradise for everybody. So you might consider what would happen if people got fed up and said, no, we're going to try this new system. Because your professor is simply teaching about a change in government, even if the professor in his lectures talk about the violent overthrow of government, because people in power are not going to give up their power easily, it's not illegal. It has to be an actual advocacy. But if you talk about it as an abstract doctrine, or you talk about it as a philosophical discussion or an educational musing, it's not a crime. Then again, if your professor goes out and tells people, okay, you get dynamite, you get guns, we're going to go to Washington and overthrow the government, that would be a crime. So you have to understand that. that even when the government makes something a crime, if all you're doing is talking about it in the abstract, you should be safe. Dennis versus United States, the first of the cases brought under the Smith Act, and the jury there found that the 11 communists who'd been charged with violating the Smith Act had in fact advocated action and so should be convicted and sent to prison. The Supreme Court upheld the conviction in a plurality decision. Remember from the lectures on Supreme Court decisions that plurality means that at least 5 justices agree with the result, but there is no one rationale that the justices agree on. So 5 guys say they should stay in prison, but there are not 5 guys who agree on the reason they should stay in prison. And of course, clear and present danger, talked about in the previous lectures. Chief Justice Vinson, in the Smith case, wrote that the 11 communists might not succeed because, after all, there's only 11 of them, and there's more than 100 million, 140 million Americans at that time. But, Chief Justice Vinson said, the fact that we're talking about the overthrow of the government means that the risk is high enough to justify the convictions. Now, Justices Black and Douglas dissent, saying the communists didn't pose risk, that they couldn't win. In fact, they pointed to the fact that no communist had ever won an election in the United States. And if they could never win, then they shouldn't be punished because, as you recall, the clear and present danger test says it has to be clear as in a real risk or threat, and present as in it's going to happen soon or it's going to happen now. And clear and present says you have to have both of these to justify the punishment of speech. Justices Black and Douglas said the communists will never win, so it's never going to be present. You only have one half of the test, and they shouldn't be punished. Chief Justice Vinson, misapplying the clear and present danger test, well, he says, if the risk is big enough, then we don't have to worry about it being present. We can get by on justifying conviction on only one half of the test. And he had 4 other justices who agreed that they should stay in prison, but he didn't have 4 other justices who agreed that it was because of the clear and present danger test. The key is that you have to be sure that you remember that not every set of words and circumstances create a clear and present danger. And we have a case, Brandenburg versus Ohio, which illustrates the point. Mr. Brandenburg was a person who did not like the fact that integration was going on. He was a strict segregationist. He was affiliated with the KKK. And one day he called a news conference and the press went out to his farm. He was there. About 6 of his buddies were there dressed in Klan regalia, you know, the hoods and the white robes, and carrying shotguns. And Mr. Brandenburg got on the back of a trailer, a hay trailer, and he talked to the press and said, this integration has got to stop. And he said that if it didn't stop, there might have to be some revengeance taken. Not a real word, but the Klan is famous for coming up with new terms. And he talked about the Klan marching 50,000 strong through Washington, D.C. to prevent integration from occurring. Now, Ohio had this law, which you see on your screen, the Criminal Syndicalism Act. And it said that it is illegal to advocate the necessity or propriety of crime, sabotage, violence as a means of accomplishing political change. And they convicted Mr. Brandenburg under that law. Supreme Court reversed his conviction. And the Supreme Court said that the law was unconstitutional. And because the law was unconstitutional, that Mr. Brandenburg's conviction had to be unconstitutional. And the way the law was unconstitutional, the Supreme Court said, was that it failed to make a distinction between mere advocacy or abstract doctrine and actual advocacy to incite lawless action. The law didn't make a distinction. Remember, under the Smith Act, you were okay if you talked about overthrowing the government as an abstract doctrine or as a philosophy or as an educational discussion. It was only real advocacy that could send you to prison. Now, Mr. Brandenburg's conviction was based upon a law that didn't provide for that distinction. The Ohio law says it doesn't matter what you're doing. If the words come out of your mouth talking about using violence or force to change government or government policy, then you automatically go to prison. And the Supreme Court there said the laws, all the laws, have to follow essentially the clear and present danger test of the constitutionality of the punishment of speech. If you don't have the clear and present danger test incorporated into your law, then your law automatically makes people guilty of expression, regardless of whether they intended to cause violence or not. And so the Brandenburg case shows us that here we have another example of overbreadth. The law was created to solve a problem, but it also wound up punishing speech that wasn't a problem. It also failed to take into account the clear and present danger test of the punishment of speech. Now remember, clear and present danger is not an actual test that is applied to speech. It is a test of whether or not the punishment of speech is constitutional. So, as I said in the previous videos, don't say somebody was convicted of violating the clear and present danger test, because there is no such statute. Clear and present danger test is a test of whether or not the law which punishes speech is constitutional or not. So, the Supreme Court there said if the government is required to prove that the speech is a call to action, it means that speech could be punished even though it didn't create a real harm. So keep that in mind. And so here we have things like threats against Democratic members of Congress and President Obama during the debate of the Affordable Care Act. A lot of people were saying, oh, it's terrible, they should be impeached, they should be thrown out of office, we should beat them out, we should shoot them. Well, unless those threats of violence were judged on the basis of whether or not they were real threats or just people talking out of their hats because they were angry, then punishment of the speech would not be constitutional. Now, keep in mind that real threats, genuine threats, can result in conviction. And in fact, there is a federal law saying you cannot threaten the life of the president. But even there, the threat against the president has to be real, and the speech has to be judged on the basis of, was this person really intending to get people to attack the president, or was this person merely expressing frustration and anxiety? The shooting that occurred in Washington just some days ago, the person posted videos on social media talking about how he didn't like the fact that Donald Trump was ascendant, he didn't like policies. That in and of itself is not enough. There has to be showing that it is a real threat. Now, in that case, it turns out the guy was deadly serious. And if he were not dead, they could prosecute him in addition to the attempted murder charge for making those threats. Now, mind you, if you look at social media, you're going to find threats by a lot of people against a lot of things. Republicans, Democrats, McDonald's, the movies, Taylor Swift, whatever. But they are only criminal if they are legitimate threats, and also if the law that punishes them makes the distinction between real threats and somebody just shooting off his or her mouth. Atari Christian Militia, that was a militia that advocated the violent overthrow of government. They were going to do this by ambushing a police officer, killing a police officer, and then ambushing the police officer's funeral. It was going to be a way to wipe out constituted government, to allow good white Christians to take over the country and make America what it was supposed to be. Their expression, along with their conspiracy to commit murder of a police officer, was enough to land them in federal prison. And the law under which they were prosecuted and convicted was one that made the distinction between real threat and just people shooting off their mouths. Let's move on to the concept of symbolic speech. Symbolic speech is the notion that actions can speak louder than words. So the Supreme Court ruled in a case, United States versus O'Brien, that actions, even though they don't involve words, can be the equivalent of speech. And when actions are considered speech, they're subject to laws of general applicability. Now, laws of general applicability are a big issue for us. So let's go over what a law of general applicability is. Law of general applicability is a law made to deal with a problem that only incidentally affects speech. And there's a three-part test to determine whether the law is constitutional or not. So, laws of general applicability are constitutional where, number one, the law furthers a substantial government interest. Number two, the interest is unrelated to suppressing speech or the press, and the restriction on speech or press goes no further than the minimum needed to further that government interest. So, let's see. Oh, speed limits. Let's say that you don't like the speed limit. Speed limit's 70. And you think that that's a bad thing. So as a protest, you're going to drive 90 miles an hour no matter where you go. You get a ticket. They arrest you for speeding. And you say, wait a minute, when I was speeding, I was symbolically speaking. My putting my foot down on the accelerator was an action that was expressive. So you can't punish me. Well, the speeding laws further substantial government interest, as in people who speed cause more accidents, there's more death, more destruction. And the laws against speeding, well, it's not really about suppressing speech. And the restriction on speech or press is no more than the minimum needed to further the government interest. So the government could say, well, yes, if you don't like the speeding laws, you can say things, you can have a bumper sticker, but you can't drive 90 miles an hour just to express your disagreement with the speeding law, because the speeding laws are laws of general applicability. So, in O'Brien, Mr. O'Brien, during the Vietnam War, a war which divided the nation, there were people who criticized the war and criticized the draft. The draft was a system in place where if you were a man, you turned 18, you had to register with Selective Service. I still think you have to do that. But in the 1960s, mid to late 1960s, and up through the 70s, when you registered for the draft, you were becoming at risk of being inducted and sent to Vietnam, which was not great. Now, you were at more risk if you were a minority person or if you were a poor person, because the people who had money could afford to send their kids to college where they would get a college deferment and couldn't be called up. And the people who were poor, couldn't go to college, they were at risk of being called up. So we'll have more about O'Brien in the next installment of the lecture. And here we are in Presentation 5 for Journalism 302 in the summer of 2017. We pick up with United States versus O'Brien. You'll recall from the last video that Mr. O'Brien, in protest of the Vietnam War and the draft system, had burned his draft card. Congress had previously passed a law making it a crime to destroy selective service records, of which the draft card was one, and so they prosecuted him. At trial and through the Circuit Court of Appeals, Mr. O'Brien won because he said he was engaged in symbolic speech opposed to the war and the draft. The federal government appealed his acquittal to the United States Supreme Court, and in the United States Supreme Court, the court did, of course, two things. Number one, they said, yes, we recognize that actions can be the equivalent of speech, creating and reinforcing the notion of symbolic speech. But then the Supreme Court found that the laws that had been created to protect draft records were put in place to protect the selective service system and ensure national security, because we would be sure to have enough people in the Army, Navy, Air Force, and Marines. Because the law was a law of general applicability, number one, meant to address a serious problem. Number two, not created simply to suppress speech. And number three, whose impact on speech was only incidental. The court said that the defense that Mr. O'Brien was engaged in a First Amendment activity would not apply. The First Amendment is no bar to prosecution under a law of general applicability. And so the Supreme Court reversed. Mr. O'Brien was then sent to prison. So, key is, if it's a law of general applicability, created to address a problem, not targeting speech, which only incidentally targets speech, then there is no First Amendment defense. And the Supreme Court was pretty clear. They said Mr. O'Brien had any number of ways in which to protest the war and the draft. He could have made a copy of his draft card and burned that, and that would have been a symbolic act, but it would not have involved the destruction of an actual selective service document. Let's move on to our next case involving laws of general applicability. United States versus Matthews. Lawrence Matthews, he was a veteran reporter. He decides to quit working for somebody else and go into freelance reporting, working for himself. Among the many stories that he'd worked on were some about child pornography. Now, we'll talk about child pornography after obscenity. Just understand that child pornography is illegal. It is a crime to possess, make, distribute, or receive child pornography. Mr. Matthews had previously interviewed law enforcement and observed them engaging online with child porn users to be able to locate them and prosecute them. He thought it was a pretty interesting story because, of course, people think of child porn users and they say, oh, these are such terrible people, how can they do this? Mr. Matthews said, well, he wasn't sure why they did this, so he decided to do an investigative story about child porn users. He couldn't necessarily go online and say, I'm a reporter, I'd like you to talk to me, because no one would talk to him. So he went online and posed as a child porn consumer. He went into chat rooms where child porn consumers were. And his plan was he would get to know these people. He'd be in the chat rooms. They would think that he was another child porn consumer. They would get to know him. They might learn to trust him, maybe even befriend him. And then he would say, oh, listen, we have this bond. I'm also a reporter, and I'd like to interview you about what it is you do and why you do it. Because pretty much it's, you get arrested, people say terrible things about you, then you wind up going to prison. Now, based upon Mr. Matthews' previous reporting, he knew some of the persons in the child porn chat rooms were law enforcement, and probably included some of the people he had interviewed before. But he was satisfied that his project was moving ahead. People had sent him child porn. He had turned it around and sent the child porn he'd received onto other folks, and he thought he was well on his way to gaining the confidence of some of these child porn consumers. And then one day, there came a knock on the door. Federal agents had an arrest warrant for him and a search warrant for his computer. Eventually, Mr. Matthews was charged with 15 counts of receiving child pornography and 15 counts of transmitting child pornography. When he went in front of the judge to make his plea, guilty or not guilty, he started off by saying, Your Honor, I'm pleading not guilty because I'm a reporter working on a story. And the judge said, stop right there. He says, but wait a minute, I'm a reporter. And the judge says, I don't care. I don't want to hear about the reporter. You cannot use reporting. You cannot use the First Amendment as a defense. You've been charged with receiving and transmitting child porn. I don't want to hear you trying to explain that you're working on a story. And in fact, when you go to trial, you're not going to be allowed to speak to the jury about being a reporter, being a journalist, and working on a story about child porn because it's not permitted. And Mr. Matthews and his lawyers were, but wait a minute, he's a journalist. He's working on a story. He's not somebody who is a person who enjoys child porn. And the judge says, you can't raise that because child porn laws are laws of general applicability, and so the First Amendment is not available to you as a defense. And then Matthew says, but that reporting, the First Amendment is my only defense. And the judge then said, you still can't use it. Eventually, the judge said she would allow Matthews to plead guilty to 1 count of sending and 1 count of receiving child porn. The other charges would be dismissed, but his guilty plea would allow him to appeal the judge's ruling about raising a reporting or First Amendment defense. His case went to the Fourth Circuit Court of Appeals. A 3-judge panel heard the appeal and said the district court judge was right. Mr. Matthews could not use reporting or the First Amendment as a defense to a charge brought under a law of general applicability. So, the key here is if you are a reporter and you want to do a story about some illegal activity, and the way you're going to get the story is by participating in the illegal activity, you better stop and rethink. Because let's say you're doing a story about gambling on campus or drug use on campus or people selling illegal liquor to minors on campus. And you get involved in that in order to work your way inside the system and see what's going on and to be able to interview people. If you get busted, you can't say I'm a reporter working on a story because the courts will not allow you to use that as an explanation or defense to a charge brought under a law of general applicability. In fact, some years ago, the National Public Radio did a story on undocumented aliens coming into the United States illegally. And so they had a reporter go down to Mexico. He found a route that aliens were using to enter the United States illegally. He went out into the desert on the U.S.-Mexico border near San Diego and Tijuana. He's talking into his microphone, talking about, here it is, the dead of night. The Border Patrol has had a vehicle pass through the area. It's now quiet. And then he describes suddenly seeing hundreds of people pop up who'd been concealed earlier, just kind of appearing by magic, and then starting to run for the border. And of course, the reporter is running along with them, describing the scene. He makes it over the border into the United States. He's running along with these hundreds of undocumented aliens when the Border Patrol shows up. They have trucks, they have loudspeakers, spotlights, and you can hear in the recording, which of course is later broadcast on National Public Radio, the Border Patrol agent saying, okay, put your hands in the air, don't move, and the reporter saying, it's all right, I'm a reporter with National Public Radio, we're doing a story on people entering the country illegally. And the Border Patrol agent is not impressed, and he doesn't care. He said, well, you entered the country illegally, you're under arrest, and he handcuffs him. Now, the National Public Radio reporter was lucky because the Immigration and Naturalization Service decided not to press charges. They could have prosecuted him. He actually committed the crime of entering the country illegally. He could have been sent to prison for that, but they decided not to prosecute him and just gave him a stern warning. But the key is the government has the ability to prosecute you if you violate a law of general applicability, and your First Amendment tattoo, wherever you have it on your body, is not going to immunize you. Okay. Well, let's move on to our next topic, and that is prior restraint, which is all about telling you to shush. Prior restraint, very restrictive in terms of controlling speech because it's not post-publication punishment. Post-publication punishment being, well, you published something, we don't like it, and now we're going to put you in jail or issue you a fine. But you've already said what you wanted to say. Prior restraint is about stopping you from saying what you want to say and stopping the public discussion before it ever occurs. We have two general types of prior restraint. We have administrative prior restraint, and then we have judicial prior restraint. And both of these are orders that tell you you cannot publish, you cannot speak about certain things. Administrative prior restraints take place in schools, public schools, where the administration has the power over publications. We won't look at those. You probably will have read the Hazelwood case. Hazelwood, of course, the leading case on administrative prior restraint. But briefly, to understand that, in Hazelwood, you had a high school newspaper. It was put out by a class. Students got academic credit for putting out the paper. The advisor was the advisor as part of her regular teaching duties. The paper was funded by the school, and so it was considered to be a classroom. And it's well-established law that schools have the power to control what happens in their classrooms. So in the Hazelwood case, the principal decided he didn't want particular stories to appear in the end-of-year edition of the paper. He yanked the stories. The editor of the paper sued the principal, and the Supreme Court said that the principal and the school were able to control their curriculum, and they didn't have to put up with anything that appeared in the curriculum that was inconsistent with the mission of the school. And for that reason, they were able to control the student newspaper. We don't talk about that much here in the class. The cases are there because the textbook is sometimes used in law schools, and I have to have that there for the law students to be able to explore. Here in California, we don't have that problem because, as you will have read in the textbook, California, by state law, makes student press the same as the professional media. So if you are a collegiate newspaper person or broadcaster, university administrations cannot censor you because you have the same First Amendment rights as the regular press, the Los Angeles Times, the San Francisco Examiner, KTLA. And so we don't have to worry about administrative prior restraints in California. Several other states similarly have laws that give press freedoms and press rights to student press. So don't worry about that. It's not going to be an answer that will be correct on the first exam. So just kind of understand that it exists, but it's not going to exist in your universe as you prepare for and take the first exam. Let's turn to what we will be dealing with, and those are judicial prior restraints. So it goes like this. Somebody hears something about something that's going to be published, Now, publishing is a term of art, means that it'll be put in a newspaper, it will be broadcast, it will be posted online, or people will say it out loud. So publishing is not just for newspapers, but somebody hears about something that's going to be published, they don't like that it's going to be published, so that person, or sometimes it's an institution, will go to a judge who has jurisdiction and asks the judge to issue an order forbidding the publication. That's an ex parte proceeding. And ex parte means only one party. It excludes the other party. So the media entity is not part of this request to the court. Only one side is there. If the judge agrees with the party going to court, then the judge will issue an order forbidding publication. The order will be delivered to the party that wants to publish, the media entity. Once the publisher has the order in hand, the publisher must follow the instructions of the court and not publish the matter that the court has ordered to be kept secret. Now, we can call these things a temporary injunction or a temporary restraining order. It's the same thing. It's temporary in nature, and it is intended simply to stop the publication of the problematic information. Once the publisher has gotten the temporary order, the publisher then gets the opportunity to come to court to argue the merits of the prior restraint in a hearing with both sides. So the judge will, at that hearing, consider the facts and the arguments and decide to do one of two things. Number one, continue the order and make it permanent, or two, dissolve the order and let the publisher publish. So that's those are the steps involved in a prior restraint. Prior restraint's been around for a long time. Here are a couple of things that it used to be illegal to talk about. Before the Civil War, it was illegal to talk about the abolition of slavery in southern states. It was illegal in some places to talk about the rights of women, including allowing women to go to school and get an education. It was illegal to talk about the rights of working people, that they should have a 40-hour week, or that they should work in a safe environment. And of course, we know in human history that it's been illegal to talk about religions other than the one true religion. The interesting thing about that is the one true religion changes over time. So in one era, one religion is the true religion, the others are banned. And then later on, one of the other religions is the true religion, and all of the others are banned. So the government is interested in keeping things quiet, though not particularly logically. Then there were also crimes to talk about or advocate allowing people to register to vote and actually vote despite the fact that they weren't white. So prior restraints have been used sometimes for good purpose, but as you can see, a lot of times for bad purposes. We will talk about prior restraints in the context of media entities and the news. And we start with Neer versus Minnesota. J. Neer and Howard Guilford had a newspaper in the Twin Cities, and they wanted to be muckraking reporters. And they pretty much hated anybody. They hated black people, they hated Jews, they hated the Catholic Church. And their newspaper was filled with stories about how the city was being run by racketeers, by mobsters, how the police department was under the control of criminals. And the people in the Twin Cities said, these are terrible things. We don't like this. How can we make these people stop? Well, Minnesota had experience with other so-called nuisance newspapers. As you can see in the book, it passed a statute in Minnesota. There was a state law that said if you had a nuisance publication, a court could enjoin you or order you to stop publication until you turned a new leaf and became respectable. Now, the earlier nuisance publication went out of business before the law could be applied, but it was still on the books when Mr. Neer and Mr. Guilford started publishing their newspaper. So city officials went to a state court. They said, here is this newspaper. It's a nuisance. It's a scandal. It's terrible. And the state court issued an injunction, enjoined publication of the paper. Neer and Guilford then went to a hearing in front of the state court judge, and the judge said, well, you have a nuisance publication. Your arguments don't hold any water with me. You can't publish until you show that you can be a respectable, decent newspaper. Neer and Guilford then appealed to the Minnesota Supreme Court. Remember, I talked in an earlier video about how the fact that states had their own protections for the press in their constitutions. Here, the Minnesota Supreme Court upheld the injunction against the publication of the paper, saying that freedom of the press only applied to responsible publishers and only decent publishers would get protection. Essentially, the Minnesota Supreme Court said, we will only protect those publications that don't need our protection. So the state protection for press was not effective there. Then Neer appeals to the United States Supreme Court, and the Supreme Court overturns the lower court decision on a 5-4 vote. Overturns the lower court, thus meaning that Neer and Guilford now are able to publish their newspapers. They're not prohibited from publishing by the order of the Minnesota courts. And Chief Justice Charles Evans Hughes writes in the opinion that the First Amendment exists to prevent previous restraints upon publication. Now, read previous restraints as in prior restraints. So Justice Hughes is saying the First Amendment is there to keep people from shutting down speakers. Also, the Neer case in 1931 is the first case in which the First Amendment was applied to newspapers. Remember from the previous video that in 1925, the Supreme Court said the First Amendment applied to individuals and that it was a national right under the 14th Amendment. Well, Neer versus Minnesota in 1931 is the first case in which the Supreme Court said, oh, by the way, newspapers are protected by the First Amendment against action by the individual states. Then, of course, the question comes up, how do we deal with nuisance publications like Neer and Guilford's newspaper, which made all sorts of outlandish and false statements about people in government? Well, Justice Hughes says, file a lawsuit, sue them for libel. That's the way to deal with it, not shut them down, but in fact, after the fact, sue them for damage to your reputation. Now, the Neer case brings up the question, are all prior restraints unconstitutional? And Justice Hughes says, no, sometimes prior restraints are constitutional under special circumstances. Now, you see the parenthetical. He's writing in 1931. Times have changed. So the list that you have from 1931 don't work today. For example, in 1931, prior restraint was okay for obstructing recruitment. If someone wanted to obstruct recruitment, you could apply a prior restraint to the person arguing that people shouldn't be put into the armed forces. That, of course, is a holdover from the Espionage Act cases of 1917. We no longer have the draft, and times have changed. And today, if you try to apply a prior restraint on people to prevent them from arguing against people joining the military, that prior restraint would fail because it involves a basic political question. So that one, constitutional prior restraint in 1931, not so today. Second, the sailing dates of shipping and troop locations. It has not been tested, but that one probably would still be constitutional. You're probably too young to remember Gulf War I. But remember that Iraq invaded Kuwait and occupied it. The United States led a coalition to expel the Iraqis from Kuwait. In the run-up to the actual war, which took just a couple of days, reporters were there for weeks and months, and there were daily press briefings. Eventually, reporters started asking some stupid questions like, oh, what part of the border with Kuwait are you going to invade through? Or where are the troops who are getting ready to invade? And of course, the Pentagon briefers would kind of roll their eyes and laugh at how stupid these reporters were. If, in fact, reporters had learned the location of troops or had learned the routes that the troops were going to take when they went into Kuwait to expel the Iraqis, that probably, in fact, I'm confident that it would be a constitutional prior restraint to prevent that sort of publication. Obscenity. Yes, you can have prior restraint for obscenity, because obscenity is outside the protection of the First Amendment. Understand, however, when we get into obscenity, you'll find that obscenity and pornography are two different things, and prior restraint against pornography is not going to be constitutional. For here, advocacy of the violent overthrow of government. Of course, this goes back to the Getlow case and the Dennis case under the Smith Act. If it's an actual advocacy of the violent overthrow of government, that's kind of difficult because, as you know from looking at the news these days, and in the previous years, there were people who were advocating tossing President Obama out of office, and the unfortunate attack on the Congress members preparing for a charity baseball game shows that people are, well, they're crazier than usual. Could we have a constitutional prior restraint on somebody advocating violent overthrow of government? It's not a question that's been addressed recently. But I think that because of the actual reality of some threats, that it might well be constitutional. But we'll have to see what happens as politics and the political divide in the country continues to grow. So as I said today, we have no bright line categories like the list from 1931. As I said, obscenity can be restrained, but it must be obscene. And pornography enjoys First Amendment protection, so likely no prior restraints. Again, military actions could be about prior restraints. Here's an interesting thing. You're, of course, aware of the noise ordinance in San Luis Obispo and maybe in other college towns. Are they prior restraints? Well, if they're not content-based, in other words, if it's not about who the singer is and what the song is, but they're only about decibels, how loud things are, then it's not really a prior restraint. It's a noise ordinance. What about an order telling jurors, and remember, of course, we will have been looking at the Bill Cosby sexual assault case out of Philadelphia. Can a judge tell jurors after a trial that they can't speak to reporters? There, we have a split of authority. Some circuit courts of appeal have said, no, that's an unconstitutional prior restraint. Others have said, no, or yes, it is constitutional because it is merely a judge maintaining control over his or her court. The key is whether or not the prior restraint is based upon the content of the expression or a general content-neutral concern. So, noise ordinances. They're not giving you a ticket because you are playing Taylor Swift. They're giving you a ticket because you have the volume set at number 11 on the volume control. Condom requirements in adult filmmaking. This came up a couple of years ago in California because of possibility of the spread of HIV and AIDS. And the question there was, is it a prior restraint on the ability of adult filmmakers to make films where the actors have sex without condoms, or is it simply a content-neutral public health issue to protect the health of the actors? There, the courts came down on the side of it's a content-neutral health law, so it was not considered to be a prior restraint. Let's move on to our next big case, 1931 Near versus Minnesota, 1970s, the Pentagon Papers. A New York Times reporter gets a copy of a 47-volume history of American involvement in Vietnam. What's happened is we've been involved in Vietnam for quite a while at this point. The Pentagon contracts out to a Washington think tank to put together a history of the American involvement in Vietnam. A person working at the think tank, Daniel Ellsberg, who is a former Marine lieutenant who'd served 2 tours of duty in Vietnam, knows the project is going on, and he goes into the office late at night and makes photocopies of the pages of the 47 volumes, sneaks them out of the think tank, and then gives the 47 volumes to a reporter for the New York Times. The New York Times spends 3 months analyzing and doing additional research, and then they start a series on Vietnam, the story of how we became involved in Vietnam, what we're doing in Vietnam, and revealing some embarrassing secrets to the public. For one thing, American ground forces had a limited role in Vietnam until the Gulf of Tonkin incident. And in the Pentagon Papers, the New York Times reported that the Gulf of Tonkin resolution that authorized American involvement in Vietnam and shipping a lot more soldiers to Vietnam had been drafted quite some time before the actual attacks reportedly occurred. So here's what happened. We had been assisting the South Vietnamese, who were, of course, opposing the North Vietnamese. One of the ways that we assisted them was we had American warships stealing through the Gulf of Tonkin in the South China Sea, monitoring electronic communications in North Vietnam. When they saw that the North Vietnamese defenses were relaxed, they would contact the South Vietnamese, who would then send commandos up along the coast to attack North Vietnamese facilities, oil storage, factories, shipping locations, that sort of thing. And then we would warn the South Vietnamese that the North Vietnamese were coming so they could get into their speedboats and hurry back home. Well, according to the news, one night, 2 American warships are steaming through the Gulf of Tonkin. It's a foggy night. They say that radar is picking up blips moving toward the American ships at high speed. And then there are reports that the ships steaming toward the American warships started firing. The American warships fire back into the foggy night. The next morning, when the sun comes up and the fog burns away, there's some damage to one of the warships. And it's like, we must have been attacked by the North Vietnamese. A couple of days later, American warships in the daylight are steaming through the Gulf of Tonkin when 5 North Vietnamese fast attack boats come out from the coast and steam toward the American warships, and they start shooting at each other. The American warships suffer some slight damage. They sink 2 of the North Vietnamese boats, and then it's reported back to the United States. And of course, members of Congress are very upset. They say, how dare the North Vietnamese attack our naval warships? And they passed the Gulf of Tonkin resolution, saying that because of the aggression of the North Vietnamese, Congress authorizes President Johnson to send thousands of American soldiers to South Vietnam to defend against North Vietnamese aggression. And that's what happened. Problem was, the resolution was written before the reports of the attack, which means most likely that the Johnson administration knew the American warships were a deliberate provocation. They kept helping the South Vietnamese, and they anticipated that at some point the North Vietnamese would attack them, and that would give them an excuse to send American ground forces to Vietnam in large numbers. The Pentagon Papers reporting from the New York Times also showed White House memos where President Johnson was signing memos committing sending U.S. troops to Vietnam, while at the same time he was going on TV to tell the American people that the situation in Vietnam was being studied, even though he'd already signed the papers to send American troops there. Now, Richard Nixon is the president then, and when the first story comes out, the Nixon White House doesn't respond, mostly because the embarrassing details are about President Johnson, a Democrat, and they anticipate embarrassing details coming out about President Kennedy. But then the Nixon White House starts thinking, well, if people realize that they'd been lied to, they might decide that we should just get out of Vietnam right now. So 48 hours after the first installment, Attorney General John Mitchell sent a telegram to the New York Times warning that the continued publication would injure U.S. defense interests, but the Times declined to kill the story. So the Justice Department goes to a federal judge in New York and asks for an injunction to prevent the Times from publishing the next article in the series. They go to Judge Murray Gerfine. Interesting thing, you can read it in the book. It was his first day as a federal judge. He'd never been a federal judge before. So her first day on the job, Justice Department lawyers come to see him, and he says, well, I'm not sure what to do. So he issues the injunction. And the order goes to the Times. They're prevented from publishing. The Times lawyers then contact Judge Gerfine. They go and have a hearing in front of him. And once he hears from the New York Times about what the story is about and why they should be allowed to publish, he dismisses the injunction. Says, okay, I'm dissolving the injunction. You convinced me that you're not doing anything wrong. But then the Justice Department goes to the Circuit Court of Appeals. They reverse Judge Gerfine's dismissal of the injunction, order it reinstated, and the Times can't publish it. The Washington Post then publishes a story with excerpts from the Pentagon Papers. The Nixon administration goes to a judge in Washington, D.C. They get an order forbidding publication. The Detroit Free Press does a story. They get a federal judge in Detroit to issue an injunction to prevent publication. And it's like the stories are popping up, but every time a story pops up, they get an injunction to prevent the publication. They get prior restraints on all these newspapers. The New York Times appeals the injunction and gets an expedited review before the United States Supreme Court. It's unheard of the speed with which they get in front of the Supreme Court. They make their arguments, and the court rules that the injunctions are not constitutional. And in the opinion, the court majority says if it's a prior restraint, there is a heavy presumption that it is not valid constitutionally. It violates the First Amendment. United States versus Progressive. Here, Progressive Magazine was going to publish a story, The H-Bomb Secret, How We Got It and Why We're Telling It. The Justice Department learned about the story and goes to a federal judge, gets an injunction against publication. Oh, if you're interested in how the Justice Department learned of the story, if you have a subscription to a magazine, or if you buy magazines at the local bookstore or a newsstand, you'll see that at the back of the magazine, invariably they will have, coming up next month, we have this story, we have that feature. And it's an attempt to get people to either subscribe or to look for the next edition of the magazine so they can buy it because of the interesting story. Well, the Progressive promoted the story about the H-bomb before that edition of the magazine came out, and that's how the Justice Department heard about it and was able to go to a federal judge to get the injunction. The Justice Department told the judge, Judge Warren, that the article had technical information about how to make an H-bomb, that the information contained in the article was top secret, protected by the Atomic Energy Act, and by telling people how the H-bomb is made, it would endanger national security and the world. At the hearing where the Progressive editor was allowed to go into court with his lawyers and argue against the Justice Department, editor Howard Moreland, and reporter of the story, said that he went into a library at Los Alamos, not the one south of San Luis Obispo, but the one in New Mexico, where the government has its nuclear weapons research program. And he says, I was in the library and I just pulled stuff off the stacks that were available to the public, and I found these things out, and that's where the story came from. So how can you stop me from publishing? This was available to the public all along. Of course, the government lawyer said, oh, well, that was a mistake. Those materials have been locked away and they're not generally available. Judge Warren, after hearing from both sides, says, well, I'm going to make my temporary injunction a permanent injunction. The Progressive magazine and reporter and editor Howard Moreland appeals. Now, Judge Warren, in his ruling, says, well, look, I've got two sides to balance. One is the First Amendment, very important to us. On the other hand, if information about the H-bomb gets out, then it could result in people learning how to make H-bombs, and of course, if they do, they'll start setting them off, or dictators could get information about making H-bombs. They would become armed with nuclear weapons. We see how problematic the North Koreans are with their nuclear arsenal. And so Judge Warren says, you know, this could lead to the destruction of civilization and humanity if the H-bomb story gets out. And he says, while the injunction, right, the prior restraint does harm to the First Amendment, if we're all just piles of glowing radioactive dust, the First Amendment doesn't mean much. So in this instance, because of the potential harm to the world, I'm going to continue my prior restraint. During the appeals process, the Madison, Wisconsin Press Connection runs a letter to the editor with information on the H-bomb, including a diagram. Other letters to the editors include information about the H-bombs. A letter was sent to Senator Charles Percy of Illinois with information about the H-bomb. Once these things come out, Judge Warren dissolves his injunction, says, okay, Progressive, you can publish your story. Now, some of you are probably scratching your heads and saying, why is that? Why is it now no longer a permissible prior restraint? Well, that's because prior restraints have to pass a three-part test to be constitutional. And it has to pass all three. Now, three-part tests are going to run through this entire course. In media law, the courts love three-part tests. So here's the three-part test. Number one, the government must show it has a substantial interest and that without the prior restraint, there will be, this quote, direct, immediate, or irreparable damage to the nation. Now, where it says nation, it doesn't have to be the whole country. It could be a region, it could be a state, it could be a municipality. So don't make this, it's not going to affect the whole country, it's only going to affect one part of the country. That harm, that direct, immediate, or irreparable harm to a part of the country would be enough to satisfy the first part of the test. Second, it has to be narrowly tailored. That is to say, it can only restrain the particular thing or things covered by number one. And third, the prior restraint must be effective. And that's what made Judge Warren's prior restraint no longer constitutional. The letters were out in the public. The information in the H1 article was out in the public. Because the information is now publicly available, the restraint on the progressive article would no longer be effective. Therefore, the restraint no longer was constitutional. And Judge Warren properly and constitutionally dissolved his prior restraint. Collateral bar. After this was all over, Howard Moreland went out to all the journalist conventions and told a story about the court fight, and he was trying to raise money to pay the legal expenses. And he would, at some point, say, I considered it at one point in the proceedings just saying, to hell with the judge, I'm going to publish the story anyway. That would have been a bad move because of something called collateral bar. Collateral bar is a rule in the courts that say if you violate an order of a court while you are appealing an order from the court, your appeal can be stricken because you violated the order. So if there's a prior restraint that a court has ordered, if you publish in violation of the prior restraint, then your appeal of the prior restraint can be stricken. More simply put, if you wind up forfeiting because you violated the rules of the game. So it was probably just as well that Howard Moreland didn't publish despite the court order. Oklahoma City bombing. We'll pick that up on the next video lecture.